Good evening, Commissioners. For the record, my name is Chris Horn. I'm a deputy prosecutor with the prosecutor's office. I've come tonight to ask the board to inform the board that some issues have arisen recently regarding the establishment of some new commercial enterprises in the unincorporated area that involve totally new dancing. The issue for the board, because no provision of the county code has ever really addressed this. We have some provisions in RCW 5.45 that address adult enterprises and were written some years ago. And the issue that I wanted to make sure the board was aware of is that this may present some unique conflicts, and to ask the board to let me know whether or not you wanted to preserve the status quo while you reviewed this to determine whether our regulations are adequate, whether we need to make any changes to accommodate these uses. They present some unique challenges to the neighborhoods and to gain information so that at the time we process and approve, if that's the ultimate decision, these applications, that we're more informed and that our process is better advised. So I'm bringing this interim resolution to you tonight related to land use and zoning pursuant to RCW 3670A 390 and 3563.200 to prohibit the receipt, processing, or approval of any application for adult entertainment enterprises, including but not limited to the display of nude men or women. I provided recitals clauses that would support this decision, and I will provide 3 copies to the Commission for your review, and I'm glad to answer any questions.
It's truly something new to Clark County, and
Thank you, Chris.
And I think I understand that not having something in place to accept or reject it, that we could be in some kind of a situation if somebody was to apply for that permit. Is that correct?
Washington has a very liberal vesting law, and when a fully complete application is filed, it's protected under the laws in effect at the time the application is filed, and that's true of any application, whether it be for a residence, a commercial application, an industrial application, or virtually any other application under the Clark County Code. Washington state law is actually not quite as liberal as even Clark County's.
Any question from the board?
Just a couple. So we do have our vesting provisions in Clark County allow for contingent vesting.
Correct.
Even before the state of Washington vesting laws kick in. So is there a project that is contingently vested at this point?
No. No, we have not received. There was questions asked and some discussion about prior to filing a pre-application, but you're correct. Pre-application is the phase at which a project can become contingently vested.
So we don't have anything even contingently vested.
Correct.
And when you said preserving the status quo, you know, does the board want to preserve the status quo? What is the status quo that we are being asked to preserve?
Well, this law would prevent any applications, which would mean there would be no totally new enterprises allowed in this county for the immediate present. And so the status quo is they don't exist at this time. And so it would that's the status quo. Maybe I wasn't very diplomatic or specific in the way I described it. But basically to maintain the current situation until the board reviews this, has an opportunity. You may ultimately decide the laws in effect right now are just the way you want them.
And that's what I guess I was getting to is does the status quo currently allow for this type of establishment in Clark County? And then kind of the other piece of that is, are these types of establishments allowed under state law? So
I'll answer your first question first, and that is I don't know the exact location because there are locational standards under Clark County Code 5.45, and so I can't tell you exactly whether it would be allowed, but in theory, yes, it would be allowed. In answer to your second question, I was not able to find a state law that prohibited totally nude or adult enterprises in the state of Washington. But in fairness, I wasn't, because of the prior meeting that we had and some other matters that have come up recently, I haven't had a lot of time to spend on this. So I was able to do some legal research regarding another issue constitutionally,
Well, it sounds like
but not on the state law.
Well, it sounds like that's the work that we would need to do.
Correct.
Got it. Okay, thank you.
Chris, I have a question. I'm looking at the section 1, third line, second sentence. It says Clark County will not accept applications for 60 days, but it doesn't say what applications for what. And I'm thinking that they would be, it's implied, Clark County will not accept applications for entertainment enterprises for 60 days. Is that correct?
Well, the whole
Clarification?
the whole paragraph starts out with, there is imposed an immediate moratorium on the location of adult entertainment enterprises, including but not limited to enterprises involving the display of nude men or women. Clark County will not accept any applications for 60 days following adoption of this resolution. That was in relation to the first sentence. So I can clarify that and add some language that makes it clear that we won't accept applications regarding adult entertainment enterprises.
Yes, that
Certainly.
that would clarify it, because basically that code hasn't been looked at for a long time. And basically I think what the idea here is that we would be able to have some time to examine that, look at that, receive public testimony, be able to make sure that we have the right code in place to find that right balance.
You okay with that?
Yeah,
Certainly.
I'm sorry. Did you?
No, I was just agreeing that I would make those changes.
Yeah, I think I think it's necessary to actually do the work on this. The code has not been revised, obviously, for a period of time, and there is a lack of clarity that maybe the planning director could actually do a similar use determination to figure out if this potential use fits within the rest of what was written, but it's not clear. So it would be good to find clarity within it. There are obviously questions. We talk about the Second Amendment protections that we have, but there are First Amendment protections that we have to consider as part of this conversation, as well as as well as the legality or illegality. So anyway, it would be good to take the time to get this right.
Yes.
So, go ahead.
The amendment of a ordinance is what we're talking about, right?
Potentially. I mean, we're going to examine it. If the board directs and if you conclude that it
Potentially.
requires a change, yes, it would
Sure.
be an amendment to the ordinance.
And that process, we've gone through that process on wineries, we've gone through it on dog kennels, and it can take longer than 60 days easily. And I wonder if this is a 60-day moratorium. Is that adequate time for us to get through the process to make sure that we can start and finish this process?
No, I don't believe it probably will be. The reason I've chosen 60 days is under state law, because this is an interim ordinance and we haven't provided notice to the public that this is being adopted. 60 days is the period to give that notice, to
Okay.
adopt findings and conclusions and allow public testimony.
So
And
it's-
then the board will reconsider it
in-
within that time frame.
I understand.
Yeah, it's not about the moratorium. It's because it's an emergency ordinance that we have to come
got
back.
that. Okay.
So what's before us right now to consider is the 60-day moratorium on what appears to be an expansion of adult entertainment that we don't have in our county yet. I'm going to be a little bit brave here and understanding what actions we're going to take tonight. If anybody else would like to comment on the resolution before us. I'm not seeing none, so I'm going to turn to the board.
Do we need to assign a number to this resolution in order to?
Yes.
Okay, you want to give us a number there?
I didn't hear.
What's that?
2014.
2014?
Oh, yeah.
0303.
Yeah, so the date.
This is the fourth.
Or yesterday, sorry.
Yeah.
Yeah.
0303. Okay. So 2014-03-03. Okay. And I guess there will be a slight amendment here to get those two words in there. So I think at this juncture, Mr. Chairman, I will make a motion to adopt Resolution 2014-03-03.
Second.
Been seconded and,
Okay, I'd like to make a
motion's
motion
been
to
made and
amend.
seconded. Yes.
Okay. Amend Section 1, second sentence, to read, to insert the two words, the 3 words, adult entertainment enterprises, between the words applications and the word for. So it would read like this: Clark County will not accept applications, after the word for adult entertainment enterprises for 60 days. So there's a word for before and after.
In section 1, I thought you said.
In section 1.
2.
You could get away with not having the 2 fours if you just inserted the language before the word applications, I think.
Oh, there you go. That's where it fits. Okay. So let me rephrase that. We will add the 3 words, adult entertainment enterprises, just before the word applications in section 1.
Second.
It's been moved and seconded to add the amendment to the resolution. I'll deal with it separately. All those in favor?
Aye.
Aye. Okay, now before us is been seconded, moved and seconded to accept the resolution 2014-03-03 as amended.
Just final thought on this?
Yes, final thought.
Just final thought on this. I'm supportive of this as an emergency ordinance to deal with an unforeseen circumstance, and then to come back and have a good public process to figure out what amendments we might need to make on the ordinance before kind of reopening it. So I think it is an unforeseen circumstance, and we will get a lot more information about something that we haven't seen in Clark County. We see it a lot in Portland, but haven't really seen it in Clark County. So there's reasons for that. There are inevitably reasons, so we need better understanding of that and of our legal responsibilities and constitutional responsibilities. We'll find out all that.
We might have to address about riding bicycles too. Just comment.
Commissioner Stewart, you said it exactly the way I wish I could have said it, so very well said.
Thank you.
All right. All those in favor?
Aye.
Aye. Good. Passes. Thank you, Chris.